Hello and welcome to a video by AIA Contract Documents. In this video, we're going to be talking about contractor delays, extensions of time, and force majeure clauses. And we're going to be doing that all in the context of the COVID-19 pandemic and the AIA's standard form contracts. My name is Mike Koger, and I'm joined by my colleague Jimmy Germano. As always, we cannot give legal advice on this video, and nothing you hear in this video should be considered as a substitute for consulting with an attorney who is licensed in your jurisdiction who can talk with you about your specific contracts and the specifics of your project. Also remember, COVID-19 issues, like all other issues, can change fairly quickly, so the information that we're providing might be out of date by the time you watch the video. So with that, Jimmy, I'm going to turn it over to you so you can tell us what the AIA contract documents have to say about delays, extensions of time, and force majeure clauses.
Thanks, Mike. So as Mike said, I'm going to talk a little bit about force majeure first and then get into contractor delays and extensions of time as related to the AIA contract documents. So first, let's a little introduction to force majeure clauses. So as Mike said, we are currently about 30 to 45 days into the COVID-19 pandemic as it hit the United States. So force majeure is on the front of everyone's mind right now. So by way of a little introduction, we'll talk about what force majeure is and where it is. And when I say where it is, I mean where is that concept within the AIA contract documents, and specifically the A201 general conditions document. We're going to get into that in a couple of slides, but first let's talk about what force majeure is. So force majeure, it's a French term. It literally translates to a superior force, and at its core, force majeure is a risk allocation principle. So force majeure allocates the risk between the parties. So here we're talking about owners and contractors as related to the A201, and it allocates the risk that a superior force, some significant event, causes either the owner or the contractor to not be able to complete their contract obligations. So who bears the risk that that is going to happen? That is fundamentally what a force majeure clause is and what it does. One thing to note is that a force majeure clause doesn't have to be titled or labeled force majeure, and it doesn't even actually have to use the term force majeure anywhere to be a force majeure clause, to do the same thing as a force majeure clause does. I'll talk a little bit about that concept within the AIA contract documents framework here in a couple slides. So as I said, we're going to talk about where force majeure is, and it's sort of a trick question because in the AIA contract documents, the term force majeure doesn't appear. Specifically in the A201 general conditions, you won't find the term force majeure, but you will find the concept of the allocation of risk for contractor delay. You'll find that in a couple articles that we're going to talk about here in a little bit. But one thing to note is that specifically with respect to the COVID-19 pandemic, I'm sure that you may have seen sample force majeure clauses and specifically clauses that have a laundry list of potential triggering events that might cause a contractor delay. So things like act of war, act of God, pandemic, hurricane, tornado, things like that. What you'll find here is, as we go forward, that the AIA documents don't necessarily include that type of laundry list, and they leave it a little bit more broad. And the reason, part of the reason why that is because there's some jurisdictions in the U.S., there is some case law to support the notion that a broadly worded force majeure clause or a broadly worded delay clause actually inures to the benefit of the parties because courts are allowed to interpret it a little bit more broadly. And what I mean by that is, what courts say sometimes is if an event is not listed in your force majeure clause, if you don't specifically say pandemic, if you don't specifically say hurricane, even if you have a catch-all, there's some courts that say then you are out of luck for the parties. So there are situations when drafting a force majeure clause more broadly would actually act to the benefit of the parties. So with that, let's get into the language here of the AIA's, what would be considered to be one of the AIA's force majeure type clauses, and that's the delay provision in the A201 2017. As you may know, the AIA contract documents are typically updated on a revolving and overlapping 10-year cycle. So the A201 was last updated in 2017. So the current version of the delay provision is 8.3.1. of the A201. If you look on the screen here, this clause that you're seeing it's one sentence, and it is a run-on sentence. It's long, but it is also, at its core, it's an if-then sentence. I've highlighted 3 words of the sentence, and that's if, then, and shall. And the reason why I've done that is because it's important to understand how this clause works, and that's what we're going to work through here over the next 2 or 3 slides, is showing how this clause is structured and why it's structured the way that it is. But you need to understand at its core that it is an if-then sentence. So if this happens, then this shall happen. And that's the 3rd word that's highlighted is shall. Shall is a term of art in the legal community, and it is, especially in contracts, in statutes and things like that. And shall means that there's very little wiggle room, and the event needs to happen. There's no discretion or very little discretion. It's not like if you were to put in the word should or could or may or might, those words would mean different things than if the word shall is used. So here you have an if, then, shall type sentence. So first you want to look at, if you're a contractor and you've been delayed, for example, you want to look at section 8.3.1 and how it works. So first, the if is if the contractor is delayed at any time. So what's meant by this is the first if portion of this sentence here, what's highlighted in yellow on your screen. If the contractor is delayed at any time, and then the next phrase is in the commencement or progress of the work. So the reason why the words commencement or progress are used in there is because the contractor can be delayed in the progress of the work, meaning they are currently performing work and now they are going to be delayed in performing that work, or they can be delayed in the commencement of work, meaning maybe they've received a notice to proceed, but they can't begin their work right now. The commencement of that work has been delayed for some reason. So either of those actions, if the contractor is delayed in either commencing or progressing in the work, could trigger a delay claim under 8.3.1. So as it relates to COVID-19 type issues, a contractor would likely look at subsection 3, and I'll highlight that on your screen right here. Subsection 3 lists a couple of events that could trigger a delay claim for a contractor, and those are unusual delay in deliveries, unavoidable casualties, or other causes beyond the contractor's control. And I've just read those 3 clauses that are highlighted there on your screen. So specifically as it relates to COVID-19, a contractor may very well experience an unusual delay in delivery. So for example, if they have a piece of equipment or some type of material that is being manufactured and delivered from overseas, they may experience a delay in that delivery. An unavoidable casualty is basically a fancy phrase for an accident that's out of the contractor's control, and that may or may not come into play with COVID-19, or this sort of mini catch-all in subsection 3, other causes beyond the contractor's control. And that goes back to what I was referencing earlier with phrasing this delay provision broadly to allow sort of as many things as possible as potential triggers if the contractor is in fact delayed at any time. So putting this together, how this clause would read as it relates to COVID-19, if a contractor is going to seek a delay or posits that it's been delayed, how the clause would read is, if the contractor has been delayed at any time in the commencement or progress of the work by an unusual delay in delivery, an unavoidable casualty, or another cause beyond the contractor's control, and then it goes back to this if-then structure of the sentence, then the contract time shall be extended for such reasonable time as the architect may determine. So with those portions of this clause highlighted on your screen, I want to focus on the last portion that's highlighted. Then the contract time shall be extended. So if you'll notice there's no flexibility with respect to whether the contract time shall be extended. So the contractor is entitled to an extension of time if they are delayed by any of these issues that are highlighted, and then the issue becomes, well, how long is the extension going to be? And that's up to the architect to determine under 8.3.1. So another potential subsection here of 8.3.1 that comes into play potentially is subsection 5. That's highlighted on your screen right now. So subsection 5, a contractor can be delayed by other causes that the contractor asserts and the architect determines justify delay. So the reason why you might be thinking to yourself, there's a mini catch-all in subsection 3 that we talked about earlier, and that's other causes beyond the contractor's control. And then there is this larger catch-all, and that's other causes that the contractor asserts and the architect determines justify delay. Those could both be triggering events for a potential delay claim. And what you'll notice here is that if you kind of pan out for a second and look at how the sentence reads now, if a contractor is going to rely on subsection 5, then the contractor has to be delayed at any time in the commencement or progress of the work by other causes that the contractor asserts and the architect determines justified delay, then the contract time shall be extended. So the architect is involved a little bit earlier in the process if the contractor is relying on subsection 5. And one of the potential reasons for this is there is no requirement under the language of 8.3.1 that the cause that the contractor asserts triggered the delay is outside of the contractor's control. At least that's the way 8.3.1 is written. So with that being the case, the contractor could potentially rely on subsection 5 or assert that it's been delayed during the commencement or progress of the work, even if there was a cause that was potentially within the contractor's control, if the architect determines that such event justifies a delay. So that's why the architect has to get involved a little bit earlier in the process here, because it's a much larger catch-all where the contractor can assert many more things that should be the basis of a delay claim. If the architect agrees with the contractor on the front end that the cause should justify a delay, then the contract time shall be extended for such time as the architect may determine, or such reasonable time as the architect may determine. So that is the framework of 8.3.1. It's sort of how it's set up and some of the reasons why it's set up. Of course, there's a lot more to 8.3.1 than we didn't even touch on, but that's some of the things particularly that might come into play with COVID-19. So some of the other things to consider here with 8.3.1 are the two clauses at the bottom that I haven't talked about, and that's 8.3.2 and 8.3.3. 8.3.2 basically just says that if the contractor is going to make a claim related to time, a delay claim under 8.3.1, such claims shall be made in accordance with the applicable provisions of Article 15. And Article 15 is going to be your claims provision, and it sets forth different requirements for how claims need to be made. And over the next slide or two, we're going to talk about some of those. Then 8.3.3 is essentially the opposite of a no damages for delay claim. And 8.3.3 just clarifies that a request for extension of time doesn't necessarily preclude recovery of damages for a delay by either party under this provision. Just because monetary damages are mentioned in 8.3.1, it's only time that it's talking about, that doesn't mean that monetary damages can't be sought. That's the only thing that 8.3.3 clarifies. So moving on to Article 15, that's the article that I mentioned earlier in 8.3.2 that might come into play. Article 15 sets forth various requirements and even some other articles throughout the contract when the contractor is going to submit claims for additional time. So under 15.1.6, specifically 15.161, if the contractor wants to make a claim for an increase in the contract time, so for example under that 8.3.1 framework, then notice shall be given as provided in section 15.1.3, which we'll talk about on the next slide. And the claim has to include an estimate of the cost and of the probable effect of the delay on the progress of the work. The contractors should be clear and they should understand their contract obligations for submitting delay claims, because there's a lot of requirements in the A201 and the various contracts, A101, 102, and 103, that might come into play. I mentioned 15.1.3 notice of claims. just understand that there's various requirements that come into play with respect to giving notice. Like we just talked about what needs to be included in a claim. 15131 talks about the timing and when a claim needs to be initiated, and the standard language sets that time limit at 21 days, and that's 21 days after the occurrence of the event giving rise to the claim, or 21 days after the claimant, so in this case it'd likely be the contractor, first recognizes the condition giving rise to the claim, whichever is later. The number of days here in 15131 is regularly modified during the negotiation of the contract, so make sure that you understand when the deadline is for submitting a claim. And then if you jump around a little bit, section 1.6.2 talks about how notice is to be delivered to the other party. The default here is certified or registered mail or by courier providing proof of delivery. And the reason why certified or registered mail or courier providing proof of delivery is required for claims specifically is that claims, the contract is set up such that claims shouldn't be mixed in with all of the other correspondence between the parties. It would be somewhat unfair for if there's hundreds of emails or if you have a project database where correspondence is back and forth. If you have 15, 20, 30 emails going back and forth about the color of the trim in a certain room, and oh, by the way, there's a $25 million delay claim in there somewhere. So that's the reason why it's kind of carved out in 162 for claims. But again, this could be modified by the parties, especially if they have a digital document or a data protocol, if they have a BIM protocol or something. This certainly could be modified, so you want to check your contract to make sure you're abiding by how you need to deliver notice. One of the specific issues that might come up here, specifically with 1.6.2 as it relates to COVID-19, is, for example, you might use the same courier who provides proof of delivery every time you submit a claim, but that courier might be closed, or maybe they are not deemed essential, so they can't operate right now. And that's one of the things that you want to check with counsel to make sure that you have options, and you want to speak with the other project parties to say, hey, we normally do it this way. Right now we can't. How should we proceed? And the one piece of advice that you'll see sort of over and over again on these types of issues is just communicate with everybody. Communicate with all the project parties. Communicate with your counsel, and make sure that if something like this pops up, specifically where there's this COVID-19 nuance that's throwing a wrench into potentially how projects are run, even with something as simple as getting a courier to provide proof of delivery or something like that. Just communicate with the project parties and develop a way forward. If you want a little bit more information on how the AIA contracts address issues related to COVID-19, there is an article that the AIA contract documents team published at the end of March that talks about some of the things that we just talked about. It also goes into a little bit more detail on some other clauses that might come into play. And of course, this recording that you're seeing now or that article can't possibly go into every single article that might come into play. So make sure you read your contract and talk to an attorney. But this could be one place to start looking for potential contract clauses at issue. And with that, turn it back over to Mike to keep us rolling.
Thanks, Jimmy. That was an excellent breakdown of Section 8.3. Every time I read a section of a contract like 8.3, it just feels like I need hypotheticals. It's like begging me to actually think in terms of hypotheticals to understand it properly. So I've got a few here that I'd like to kind of bounce back and forth with you and see if we agree on. And then, and by the way, they're going to go from easiest to hardest. So the first hypothetical is, let's say I'm a contractor and I'm working in a state or jurisdiction where my mayor or my governor has banned construction entirely. It's not deemed essential. I'm not allowed to even get on my job site. Do you think that is something that would qualify as an excusable delay that I might be able to get compensated for and a time extension for under Section 8.
I would agree that's probably the easiest of the potential scenarios that are happening right now, and it'd be difficult to imagine a scenario where that doesn't trigger a valid delay claim, where the contractor literally it is illegal for them to perform work right now. They cannot go to the job site. So something, a mandate, a proclamation, a new law has come into place and precluded them from doing their job. I would imagine in all likelihood that would form the basis of a valid delay claim. What do you think about that?
Yeah, I agree. I mean, this one, there's, as attorneys, we like to think of there being an exception to every rule, but we've talked about, and we've been hearing about closures and job sites being, or construction being banned in states for a couple of weeks now, and I still can't think of a really good exception, as to why that would not be an excusable delay. So that one's pretty black and white for me. There might be exceptions. You can probably think of a fact pattern that could exist where that's not true, but that one to me is pretty black and white. So let's go on to something a little more nuanced. So let's say I'm working in a jurisdiction where construction is not banned, but I've got materials and equipment that's delayed or is impossible to get. Things that 2 or 3 months ago when I signed the contract I could have readily got them quickly, but now I just can't. Is that the kind of thing that would qualify me for an excusable delay under 8.3?
So I think that 8.3 has the phrase in it, an unusual delay in delivery. So a delivery delay certainly is the kind of thing that 8.3.1 anticipated as a potential basis for a delay claim. For this one, I kind of need to know a little bit more about the delay itself. For example, if there is a delay in overseas, some type of equipment or material from overseas that is delayed in delivery, that could potentially form a basis of a delay claim if that type of work or that particular facet of the job, for example, is on the critical path and you can't do anything else until this one thing or this one type of material is delivered. But if it's not on the critical path, then I think a contractor has to think hard about how they can work around this delay and potentially mitigate their damages and say, maybe we didn't get this delivery on time, this delivery was delayed, but we can go over here and work on this aspect of the project instead. Then, this particular item may have been delayed, but the project isn't necessarily delayed as a result. So I probably would need to know a little bit more, but certainly a significant and unusual delay in delivery is the kind of thing that could form the basis of a delay claim under 8.3.1.
I agree. I mean, this one, is definitely more gray area for me, and we need to know more information. That's why we always give the disclaimer at the beginning of these videos, and this is the reason, we would need to know just more about the factual scenario in order to really weigh in about how 8.3 would treat, delays of that nature. If it's you got to, like you said, you got to think in terms of critical path, and if you've got door hardware that's delayed, but you're still just pouring foundations, is that something that, yeah, it's a delay, but does that really put you off of your schedule in a real meaningful way? Probably not. But if you can't literally get formwork, or you can't get your concrete trucks to be on the site, that probably would delay you. So that's where you just got to know more, and you have to kind of parse through those at a more granular level than we're able to do in this video. So now for one's a bit more tricky. Let's say that there's no ban on construction, but in my area, and I'm a contractor, but I see recommendations from like the CDC, or I'm just generally worried about safety, job site safety, and I know while there's a lot of things that are up in the air about how contracts would deal with, and how just I as a contractor should be dealing with COVID-19 issues, I do know that job site safety is something that I'm responsible for. What do you think contractors should be doing? Not just what should they be doing in that scenario, but are those the kinds of things that might qualify for a delay under 8.3?
Yeah, this one is tricky. I think that there's no good answer. The answer is probably it depends. But I think some of the things that a contractor, specifically a contractor, would need to consider would be something like, if it's a relatively small project, if it's a project that's maybe a tenant rebuild or rehab of a relatively small space, can they actually physically adhere to the CDC guidance and guidelines for spacing between people and cleanliness of the job site, and et cetera, while also doing their job. So I do think that these are the kinds of issues that tend to be way more right on the line between are you actually able to do your job and complete your project or not? And maybe there's no order in place, so you can't say no for sure, but you also can't say yes for sure because there's a lot of guidance out there that may, in effect, preclude you from doing your work. So I think in this situation, the best thing to do would be to consult an attorney and to say, these are all of the things that are happening in our jurisdiction, and does this mean we can't perform our work, or can we perform our work, and what types of issues come into play? One of the nuanced issues I think there is, the contractor has, at least under the AIA framework, has an obligation to ensure job site safety, and every employer has an obligation to ensure employee safety. So if a contractor number one has to keep the job site safe, and that's not necessarily defined, particularly as it relates to COVID-19. So what does that mean with respect to COVID-19? And then every employer under OSHA has an obligation to keep their employees safe and to provide a safe workspace. And there might be other laws that come into play as well. But how does a contractor keep its employees safe against something like COVID, when you typically think of other issues on a construction site when you're talking about job site and employee safety, whereas this one might now come into play, and contractors, I think, have to think about that with respect to their employee obligations and their contract obligations. So I say that to say all of that comes into play when trying to figure out whether or not a contractor can actually do work. Is that what you were thinking with that one, or did you have a different thought?
No, I definitely agree. I mean, I think that, the topic of job site safety has really taken on new meaning here over the last month or two. I mean, this is not something that contractors are, social distancing, washing your hands all the time. This is not the kind of thing that contractors tend to think of when they think in terms of job site safety, but probably should start thinking along the lines of already. It's interesting when I've talked about this topic a couple of times over the last few weeks, and I can distinctly remember a couple of weeks ago when we initially talked about this, we kind of both threw up our hands and said, we don't know. This is, if you are delayed because you have to slow down your work, then sure, it'll probably be, you'll be able to get additional time and compensation under 8.3, but how do you go about doing that? We didn't really know. What's interesting is that over the last 2 weeks or so, we've seen just a flood of information come out. Some of it is mandatory by, like the District of Columbia, I think, published it was actually mandates for construction workers to follow certain steps. I know other states have done that, but there's also we've just been inundated with, webinars, videos, like checklists, recommendations, those kinds of things from folks, trade associations in the industry. So it's a tough day right now for general counsels with construction firms, because they're going to have to parse through all that and figure out what their best, steps are for their particular projects. I did kind of create a little checklist of kind of mine as far as a hierarchy of what I would be thinking of. The first thing I would do is see if there's anything like mandatory out there for me to do as a contractor in my specific state. I also read something recently by the state of Ohio had published, I can't remember if they were guidelines or if they were mandates for practices on a construction site. So check to see if there's anything mandatory in your state, because by now there might be. And then, also consider recommendations by non-binding sources, like, if the AGC has something out there, that would help general contractors understand what they should be thinking about, social distancing, limiting the number of trades that are on a site, limiting the number of people that are on a site, and again, all while thinking in terms of, if I have to slow down the project or if I'm incurring extra money due to these, mitigation efforts, how do I, are those things that I can quantify and then capture under 8.3? And I just will also caution that it's, I was talking with a general contractor recently, and he mentioned that it's not as simple as just social distancing on a construction site. There are, a lot of activities that go on a construction site that require, multiple people to be in kind of clustered areas. If you're doing a high-rise kind of a building, you've got to think about vertical transportation and how to get, people up and down the building without passing each other constantly in the stairwells, those kinds of things. So this is a big effort for contractors. And then ultimately, if you can't provide a safe job site, then you're going to have to make some tough decisions and work with the owner. I think to either highly limit the amount of work that goes on, or perhaps even delay the project because you simply can't provide a safe job site. I think we've exhausted that one. I guess we'll go ahead and wrap up with just one more quick topic. Do you have any, now that we've talked all the way through delays and extensions of time, that kind of thing, do you have any tips for contractors as they're, working through this? Just one or two things?
Yeah, sure. So I think that I can't remember where I saw it, but I saw something recently that I thought summed up the kind of the hierarchy of where contractors should look, and it described it as the 3 C's, and it consult your contract, consult an attorney, and communicate with the project parties. And we've talked about each of those 3 things here over the last 10, 15 minutes, but I think that's at least a great place to start, is look to your contract language, understand your requirements, your obligations, and your rights, and then consult with an attorney to understand a little bit more about that and to act on your behalf if you need to, and then communicate with all the project parties. So this is sort of uncharted territory for everyone up and down the chain, and I think the best thing everyone can do is be very open and communicate about the struggles that they're having, but also what they are trying to accomplish, how they're trying to get there, what their incentives are, and try and work together to come to a solution.
Absolutely. And I'll add to that, definitely if there is a notice requirement for either for a claim, for additional time or compensation due to a delay, make sure that you're following the letter of your contract for any notice requirements. Also, it's one thing to be entitled to additional compensation and time for a delay. It's another thing to be able to prove it in a way that doesn't cause conflict. Document all of these, delays, and make sure that you are, separating out your regular costs and your regular time scheduling kind of issues from the things that are truly caused by a delay when it comes time to actually get compensation or an extension of time from an owner. In my experience, if you have all that paperwork, if you have all that backup information, well organized and well thought out, it's just going to be a lot easier and less friction. So that's all I have.
Yeah, absolutely. That's a great point. So I think with that, I'll just kind of provide some general information, some contact and help resources. Again, if you have any follow-up questions or want to learn more information about the AIA Contract Documents Program, the aiacontract.org/learn page has a ton of useful information, articles, resources, checklists, explanatory guides for each of the documents. And then if you have further questions about either the document content or the online service when you're utilizing any of the AIA contracts, the information to contact either of those resources is up on the screen right now. Thank you very much for attending, and that's all I got. Mike, how about you?
That's it for me. Thank you very much, Jimmy. Appreciate it.